Good evening, Dean, classmates. Tonight, I will be reporting on Financial Rehabilitation and Insolvency Act of 2010, particularly on chapters 7 to 10. Chapter 7, Provisions common to liquidation in insolvency of individual and juridical debtors. So, Section 111, Use of term debtor. For purposes of this chapter, the term debtor shall include both individual debtor as defined in Section 4, Paragraph O, and debtor as defined in Section 4, Paragraph K of this Act. Section 112, the liquidation order. The liquidation order shall declare the debtor insolvent, order the liquidation of the debtor, and in the case of juridical debtor, declare it as dissolved, order the sheriff to take possession and control of all the property of the debtor, except those that may be exempt from execution, order the publication of the petition or motion in a newspaper of general circulation once a week for 2 consecutive weeks, direct payments of any claims and conveyance of any property due the debtor to the liquidator, prohibit payments by the debtor and the transfer of any property by the debtor, direct all creditors to file their claims with the liquidator within the period set by the rules of procedure, authorize the payment of administrative expenses as they become due, state that the debtor and creditors who are not petitioners may submit the names of other nominees to the position of liquidator and set the case for hearing for the election and appointment of the liquidator, which date shall not be less than 30 days nor more than 45 days from the date of the last publication. For the effects of the liquidation order, upon the issuance of the liquidation order, a juridical debtor shall be deemed dissolved and its corporate or juridical existence is terminated. Legal title to and control of all the assets of the debtor, except those that may be exempt from execution, shall be deemed vested in the liquidator, or pending his election or appointment with the court. All contracts of the debtor shall be deemed terminated and or breached unless liquidator within 90 days from the date of his assumption declares otherwise and contracting parties agree. No separate action for the collection of an unsecured claim shall be allowed. Such action already pending will be transferred to the liquidator for him to accept and settle or contest. If the liquidator contests or disputes the claim, the court shall allow, hear, and resolve such contest except when the case is already on appeal. In such a case, the suit may proceed to judgment, and any final and executory judgment therein for a claim against the debtor shall be filed and allowed in a court, and no foreclosure proceedings shall be allowed for a period of 180 days. Rights of secured creditors. The liquidation order shall not affect the right of a secured creditor to enforce his lien in accordance with the applicable contract or law. A secured creditor may waive his right under the security or lien, provide his claim in the liquidation proceeding, and share in the distribution of the assets of the debtor, or maintain his rights under his security or lien. If the secured creditor maintains his rights under the security or lien, the value of the property may be fixed in a manner agreed upon by the creditor and the liquidator. When the value of the property is less than the claim it secures, the liquidator may convey the property to the secured creditor, and the latter will be admitted in the liquidation proceeding as a creditor for the balance. If its value exceeds the claim secured, the liquidator may convey the property to the creditor and waive the debtor's right of redemption upon receiving the excess from the creditor. Second, The liquidator may sell the property and satisfy the secured creditor's entire claim from the proceedings of the sale, or the secured creditor may enforce the lien or foreclose the property pursuant to the applicable laws. The liquidator. Section 115, Election of Liquidator. Only creditors who have filed their claims within the period set by the court and whose claims are not barred by the statute of limitations will be allowed to vote in the election of the liquidator. A secured creditor will not be allowed to vote unless, letter A, he waives his security or lien, or B, has the value of the property subject of his security or lien fixed by agreement with the liquidator and is admitted for the balance of his claim. The creditors entitled to vote will elect the liquidator in open court. The nominee receiving the highest number of votes cast in the terms of amount of claims and who is qualified pursuant to Section 118 hereof shall be appointed as liquidator. The court may appoint the liquidator if, on the date set for the election of the liquidator, the creditors do not attend. The creditors who attend fail or refuse to elect a liquidator. After being elected, the liquidator fails to comply, or a vacancy occurs for any reason whatsoever. In any cases provided herein, the court may instead set another hearing for the election of the liquidator. Provided further that nothing in this section shall be construed to prevent a rehabilitation receiver who was administering the debtor prior to the commencement of the liquidation from being appointed as liquidator. Section 117 provides that oath and bond of the liquidator prior to entering upon his powers, duties, and responsibilities, the liquidator shall take an oath and file a bond in such amount to be fixed by the court, conditioned upon the proper and faithful discharge of his powers, duties, and responsibilities. So what are the qualifications of a liquidator? The liquidator shall have the qualifications enumerated in Section 29 hereof. He may be removed at any time by the court for cause either motu proprio or upon motion of any creditor entitled to vote for the election of the liquidator. The powers, duties, and responsibilities of the liquidator shall be deemed an officer of the court with the principal duty of preserving and maximizing the value and recovering the assets of the debtor, with the end of liquidating them and discharging to the extent possible all the claims against the debtor. The powers, duties, and responsibilities of the liquidator shall include but not limited to sue and recover all the assets, debts, and claims belonging to or due to the debtor, to take possession of all properties of the debtor except property exempt by law from execution, to sell with the approval of the court any property of the debtor which has come into his possession or control, to redeem all mortgages and pledges, and to satisfy any judgment which may be encumbrance or any property sold by him, to settle all accounts between the debtor and his creditors, subject to the approval of the court, to recover any property or its value fraudulently conveyed by the debtor, to recommend to the court the creation of a creditors committee which will assist him in the discharge of his functions and which have powers as the court deems just, reasonable, and necessary, and upon approval of the court, to engage such professionals as may be necessary and reasonable to assist him in the discharge of his duty. In addition to the rights and duties of a rehabilitation receiver, the liquidator shall have the right and duty to take all reasonable steps to manage and dispose of debtors' assets with a view towards maximizing the proceedings therefrom, to pay the creditors and stockholders, and to terminate the debtor's legal existence. Other duties of the liquidator in accordance with this section may be established by procedural rules. A liquidator shall be subject to removal pursuant to procedures for removing a rehabilitation receiver. For the compensation of the liquidator and the persons and entities engaged or employed by him to assist in the discharge of his powers and duties shall be entitled to such reasonable compensation as may be determined by the liquidation court, which shall not exceed the maximum amount as may be prescribed by the Supreme Court. Reporting requirements: the liquidator make and keep records of all monies received and all disbursements made by him or under his authority as liquidator. He shall render a quarterly report thereof to the court, which report shall be made available to all interested parties. The liquidator shall also submit such reports as may be required by the courts from time to time, as well as a final report at the end of the liquidation proceeding. The discharge of liquidator in the preparation for the final statement of all claims against the debtor. The liquidator will notify all the creditors either by publication in a newspaper of general circulation or such other mode as the court may direct or allow, that he will apply with the court for the settlement of his account and his discharge from liability as liquidator. The liquidator will file a final accounting with the court with proof of notice to all creditors. The accounting will be set for hearing. If the court finds the same in order, the court will discharge the liquidator. Nature of office of liquidator. A liquidator in insolvency occupies a triple position. First, he is an officer of the court. Second, he is the representative of the insolvent debtor and the administrator of the properties belonging to the latter. Third, he is also a representative of the creditors, especially in all actions and proceedings to set aside preference and fraudulent transactions entered into by the debtor. How liquidator is chosen? A liquidator in insolvency is elected by the creditors of the insolvent at the meeting set by the court. As a rule, all creditors of the insolvent are entitled to vote at the election of the assignee except the following. Number 1. Those who did not file their claims in the court in which proceedings are pending within the period set by the court. Number 2. Those whose claims are barred by the statute of limitations. And number 3, a secured creditor will not be allowed to vote unless he waives his security or lien or has value of the property subject of his security or lien fixed by agreement with the liquidator and is admitted for the balance of his claim. Secured creditors. As a general rule, a creditor who holds any mortgage, pledge, or lien of any kind as security of the payment of his claim is not affected by the liquidation order. and thus, the secured creditor may still enforce his lien in accordance with the applicable contract or law. A secured creditor may, however, letter A, as we've learned earlier, waive his right under the security or lien, prove his claim in the liquidation proceedings, and share in the distribution of the assets of the debtors, or letter B, maintain his rights under the security or lien. If the secured creditor maintains his rights under the security or lien, the value of the property may be fixed in a manner agreed upon by the creditor and the liquidator. When the value of the property is less than the claim it secures, the liquidator may convey the property to the secured creditor, and the latter will be admitted in the liquidation proceedings as a creditor. For the balance, if its value exceeds the claim secured, the liquidator may convey the property to the creditor and waive the debtor's right of redemption upon receiving the excess from the creditor. Or, number 2, the liquidator may sell the property and satisfy the secured creditor's entire claim from the proceeds of the sale. Or, number 3, the secured creditor may enforce the lien or foreclose on the property pursuant to applicable laws. A secured creditor will not be allowed to vote unless he waives his security or lien, or has the value of the property subject of his security or lien fixed by agreement with the liquidator, and is admitted for the balance of his claim. Vote necessary. The nominee receiving the highest number of votes cast in terms of amount of claims and who is qualified pursuant to Section 118 hereof shall be appointed as the liquidator. Note that double majority in suspension of payments does not apply here. When the liquidator appointed by the court, ordinarily, the liquidator in insolvency is elected by the creditors of the insolvent. However, the court may appoint the liquidator if, on the date set for the election of the liquidator, the creditors do not attend. The creditors who attend fail or refuse to elect a liquidator. After being elected, the liquidator fails to qualify, or a vacancy occurs for any reason whatsoever. In any of the cases provided herein, the court may instead set another hearing of election for or of the liquidator. And now for the powers, duties, and responsibilities of the liquidator. The powers, duties, and responsibilities of the liquidator shall include but not limited to, letter A or number 1, to sue and recover all the assets, debts, and claims belonging or due to the debtor. Number 2, to take possession of all the property of the debtor, except property exempt by law from execution. Number 3, to sell with approval of the court any property of the debtor which has come into his possession or control. Then number 4, to redeem all mortgages and pledges and to satisfy any judgment which may be an encumbrance on any property sold by him. Number 5, to settle all accounts between the debtor and his creditors, subject to the approval of. Number 6, to recover any property or its value fraudulently conveyed by the debtor. Number 7, to recommend to the court the creation of a creditors committee which will assist him in the discharge of the functions and which shall have powers as the court deems just, reasonable, and necessary, and, upon approval of the court, to engage such professional as may be necessary and reasonable to assist him in the discharge of his duties. Determination of claims. Section 123, Registry of Claims. Within 20 days from his assumption into office, the liquidator shall prepare a preliminary registry of claims of secured and unsecured creditors. Secured creditors who have waived their security or lien or have fixed the value of the property subject of their security or lien by agreement with the liquidator and is admitted as a creditor for the balance shall be considered as unsecured creditors. The liquidator shall make the registry available for public inspection and provide publication notice to creditors, individual debtors, owners of sole proprietorship debtor, the properties of partnership debtor, and shareholders or members of the corporation debtor, on where and when they may inspect it. All claims must be duly proven before being paid. Section 124, the right of set-off. If the debtor and a creditor are mutually debtor and creditor of each other, one debt shall be set off against the other, and only the balance, if any, shall be allowed in the liquidation proceedings. Section 125, opposition or challenge to claims. Within 30 days from the expiration of the period for filing of application for recognition of claims, creditors, individual debtors, owners of the sole proprietorship debtor, partners of the partnership debtor, and shareholders or members of the corporation debtor, and other interested parties may submit a challenge to a claim or claims to the court, serving a certified copy on the liquidator and the creditor holding the challenge claim. Upon the expiration of the 30-day period, the rehabilitation receiver shall submit to the court the registry of claims containing the undisputed claims that have not been subject to challenge. Such claims shall become final upon the filing of the register and may be subsequently set aside only on grounds of fraud, accident, mistake, or inexcusable neglect. Section 126, or the submission of disputed claims to court. The liquidator shall resolve disputed claims and submit his findings thereon to the court for final approval. The liquidator may disallow claims. Avoidance proceedings. Section 127, or the rescission or nullity of certain transactions. Any transactions occurring prior to the issuance of the liquidation order, or in case the conversion of the rehabilitation proceedings to liquidation proceedings prior to the commencement date entered into by the debtor, or involving its assets, may be rescinded or declared null and void on the ground that the same was executed with the intent to defraud a creditor or creditors, or which constitutes undue preference of creditors. The presumptions set forth in Section 58 hereof shall apply. Section 128, actions for rescissions or nullity. The liquidator or his conformity, a creditor may initiate and prosecute any action to rescind or declare null and void any transaction described in the immediately preceding paragraph. If the liquidator does not consent the filing or prosecution of such action, any creditor may seek leave of the court to commence said action. If the court or if leave of court is granted under subsection A hereof, the liquidator shall assign and transfer to the creditor all rights, titles, and interest in the sues in action or subject matter of the proceeding, including any document in support thereof. Any benefit derived from a proceeding taken pursuant to subsection A hereof to the extent of his claim and the cost belongs exclusively to the creditor instituting the proceeding, and the surplus, if any, belongs to the estate. Where before an order is made under subsection A hereof, the liquidator signifies to the court his readiness to institute the proceeding for the benefit of the creditors. The order shall fix the time within he shall do so, and in that case, the benefit derived from the proceedings, if instituted within the time limits so fixed, belongs to the estate. The liquidation plan. Section 129 provides that the liquidation plan, within 3 months from his assumption into office, the liquidator shall submit a liquidation plan to the court. The liquidation plan shall, as minimum, enumerate all the assets of the debtor, all the claims against the debtor, and a schedule of liquidation of the assets and payment of the claims. Section 130, exempt property to be set apart. It shall be the duty of the court, upon petition and after hearing, to exempt and set apart for the use and benefit of the said insolvent such real and personal property as is by law exempt from execution, and also a homestead, but no such petition shall be heard as aforesaid until it is first proved that notice of the hearing of the application therefore has been duly given by the clerk, by causing such notice to be posted in at least 3 public places in the province or city at least 10 days prior to the time of such hearing, which notice shall set forth the name of the said insolvent debtor and the time and place appointed for the hearing of such application, and shall briefly indicate the homestead sought to be exempted or the property sought to be set aside, and the decree must show that such proof was made to the satisfaction of the court and shall be conclusive evidence of the fact. Section 131, or the sale of assets in liquidation. The liquidator may sell the unencumbered assets of the debtor and convert the same into money. The sale shall be made at public auction. However, a private sale may be allowed with the approval of the court. If the goods to be sold are of a perishable nature or are liable to quickly deteriorate in value, or are disproportionately expensive to keep or maintain, or the private sale is for best interest of the debtor and his creditors. With the approval of the court, unencumbered property of the debtor may also be conveyed to a creditor in satisfaction of his claim or part thereof. Section 132, or the manner of implementing the liquidation plan. The liquidator shall implement the liquidation plan as approved by the court. Payments shall be made to the creditors only in accordance with the provision of the plan. Section 133, or the concurrence and preference of credits. The liquidation plan, in its implementation, shall ensure that the concurrence and preference of credits as encumbered in Civil Code of the Philippines and other relevant laws shall be observed unless preferred creditor voluntarily waives his right or his preferred right. For purposes of this chapter, credits for services rendered by employees or laborers to the debtor shall enjoy first preference under Article 2244 of the Civil Code unless the claims constitute legal liens under Articles 2241 and 2242 thereof. As we mentioned in Section 130, properties which will not pass to the liquidator. As a rule, legal title to and control of all the assets of the debtors or the debtor, except those that may be exempt from execution, shall be deemed vested in the liquidator or pending his election or appointment with the court. Control includes the transfer of the possession of all the properties of the insolvent debtor to the liquidator in insolvency. However, the following properties will not pass to the liquidator in insolvency. Number 1, property exempt from execution. Number 2, homestead. Number 3, property held in trust. Number 4, right of action for personal injury to the insolvent. Number 5, expectancy to inherit. Number 6, encumbered property. Number 7, life insurance policy even if the proceeds are payable to the insolvent himself or his legal representative. If it has no cash, surrender the value at the time of the commencement of the proceeding in insolvency. Section 133 also requires in no uncertain terms that the liquidation plan in its implementation shall ensure that the concurrence and preference of credits as enumerated in the Civil Code of the Philippines and other relevant laws shall be observed unless a preferred creditor voluntarily waives his preferred right. For example, if there are unpaid real estate taxes over a piece of land belonging to the insolvent debtor, the plan must ensure the relevant local government unit must partake first from the proceeds of the sale of the said land. Article 2242, paragraph 1 of the Civil Code provides such taxes have preference over all other claims and must be paid first pursuant to Article 2243 of the same code. Order of application of assets to payment. The liquidator shall discharge the liabilities of the debtor by applying the assets of the insolvent in accordance with the liquidation plan provided. The concurrence and preference of credits as provided in the Civil Code shall be observed. The following should be the order of payment. Number 1, exclude properties exempt from execution. Number 2, pay credits enjoying preference with respect to specific movable or immovable property. Number 3, pay credits enjoying preference with respect to other properties of the debtor, real or personal. And number 4, pay all credits not enjoying any preference pro rata regardless of dates. Preference. Preference is an exemption to the general rule and is what its name implies. By it, one person is given superior rights or right or claim over another. For such reason, the law as to preference shall be strictly construed. There are 3 preferred credits recognized by law: those with respect to movable properties of the debtor, those with respect to immovable properties of the debtor, and those with respect to other properties of the debtor. Credits of any kind or other kind or class shall enjoy no preference. Preferred claims on specific movable property, Article 2241 of the Civil Code. With respect to specific movable property of the debtor, the following claims or liens shall be preferred. Number 1, duties, taxes, and fees due thereon to the state or any subdivision thereof. Number 2, claims arising from misappropriation, breach of trust, or malfeasance by public officials committed in the performance of their duties on movables, money, or securities obtained by them. Number 3, claims for the unpaid price of movables sold on said movables so long as they are in the possession of the debtor up to the value of the same. And if the movable has been resold by the debtor and the price is still unpaid, the lien may be enforced on the price. This right is not lost by the immobilization of the thing by destination, provided it has not lost its form, substance, and identity. Neither is the right lost by the sale of the thing together with other property for a lump sum, when the price thereof can be determined proportionally. Number 4, credits guaranteed with a pledge, so long as the thing pledged are in the hands of the creditor, or those guaranteed by a chattel mortgage upon the things pledged or mortgaged up to the value thereof. Number 5, credits for the making, repair, safekeeping, or preservation of personal property on the movable, thus made, repaired, kept, or possessed. Number 6, claims for laborers' wages on the goods manufactured or work done. For number 7, for expense of salvage upon the goods salvaged. 8, credits between the landlord and the tenant arising from contract of tenancy on shares, on the share of each in the fruits or harvest. Number 9, credits for transportation upon the goods carried, for the price of the contract and incidental expenses until their delivery and for 30 days thereafter. Number 10, credits for lodging and supplies usually furnished to travelers by hotel keepers on the movables belonging to the guest as long as movables are in the hotel, but not for money loaned to the guest. Number 11, credits for the seeds and expenses of cultivation and harvest advanced to the debtor upon the fruits harvested. Number 12, credits for rent for 1 year upon the personal property of the lessee existing on the immovable list and on the fruits of the same, but not on money or instrument of credit. Number 13, claims in favor of the depositor if the depository has wrongfully sold the thing deposited upon the price of sale. Effects of preference. Those credits which enjoy preference with respect to specific movables exclude all others to the extent of the value of the personal property to which the preference refers. And if there are 2 or more credits with respect to the same specific movable property, they shall be satisfied pro rata after the payments of duties, taxes, and fees due the state or any subdivision thereof. Taxes and fees due the state, therefore, take precedence in the payment of claims on specific movable property. Preferred claims on specific immovable property, Article 2242 of the Civil Code. Number 1, taxes due upon the land or building. Number 2, the unpaid price of real property sold upon the immovable sold. Number 3, claims of laborers, masons, mechanics, and other workmen, as well as of architects, engineers, and contractors engaged in the construction, reconstruction, or repair of buildings, canals, or other works upon said buildings, canals, or other works. Number 4, claims of furnishers of materials used in the construction, reconstruction, or repair of buildings, canals, or other works upon said buildings, canals, or other works. Number 5, mortgage credits recorded in the Registry of Property upon the real estate mortgage. Number 6, expenses for the preservation or improvement of real property when the law authorizes reimbursement upon immovable, preserved, or improved. Number 7, credits annotated in the Registry of Property in virtue of a judicial order by attachments or executions upon the property affected and only as to later credits. Number 8, claims of co-heirs for warranty in the partition of an immovable among them upon the real property thus divided. And number 9, claims of donors of real property for pecuniary charges or other condition imposed upon the donee upon the immovable donated. Number 10, credits of insurers upon the property insured for the insurance premiums for 2 years. Effects of preference. The effects of preference on specific immovable property are the same as in preference of specific movable property. Thus, those credits which enjoy preference in relation to specific real property or real rights exclude all others to the extent of the value of the immovable or real right to which the preference refers. And if there are 2 or more credits with respect to the same specific real property or real rights, they shall be satisfied pro rata after the payments of taxes and assessments upon the immovable property or real right. Furthermore, the preferred claims on specific movable or immovable properties shall be considered as mortgages or pledges of real or personal property or liens within the purview of legal provisions governing insolvency. Taxes, however, must first be satisfied. Preferred claims in other properties, Article 2244 of the Civil Code. With reference to other property, real and personal, of the debtor, the following claims or credits shall be preferred in the order named. Number 1, proper funeral expenses for the debtor or children under their parental authority who have no property of their own when approved by the court. Number 2, credits for services rendered the insolvency by employees, laborers, or household helpers for 1 year preceding the commencement of the proceedings in insolvency. Number 3, expenses during the last illness of the debtor or of their spouse and children under their parental authority if they have no property of their own. Number 4, compensation due to the laborers or their dependents under laws providing for indemnity for damages in cases of labor accidents or illness resulting from the nature of the employment. Number 5, credits in advancement made to the debtor for support of themselves and family during the last year preceding the insolvency. Number 6, support during the insolvency proceedings and for 3 months thereafter. Number 7, fines and civil indemnification arising from a criminal offense. Number 8, legal expenses and expenses incurred in the administration of the insolvent's estate for the common interest of the creditors when properly authorized and approved by the court. Number 9, taxes and assessments due to the national government other than those mentioned in Article 2241 number 1 and 2242 number 1. Number 10, taxes and assessments due to any province other than those referred to in Articles 2241 number 1 and Article 2242 number 1. Taxes and assessments due to any city or municipality other than those indicated in Article 2241 number 1 and 2242 number 1. 12. Damages for death or personal injuries caused by a quasi-delict. Number 13. Gifts due to public and private intentions of charity or beneficence. 14. Credits that without special privilege appear in a public instrument. or in a final judgment if they have been the subject of litigation. Wages. Credits for services rendered by employees or laborers shall enjoy first preference under Article 2244 of the Civil Code unless the claims constitute legal liens under Articles 2241 and 2242 thereof. Wages of laborers must first be paid before other creditors. However, in such a case, prior judicial declaration of insolvency is necessary. Hence, an employee cannot enforce preference for wages over other creditors in the absence of a declaration of bankruptcy or judicial liquidation of the assets of the employer. Claims not preferred. After payment of claims preferred with respect to specific property, real or personal, the excess shall be added to the assets of the debtor for payment of other creditors. Thereafter, the preferred claims as to other properties of the debtor will be paid in the order established in Article 2244 of the Civil Code. Whenever may be left, or whatever may be left, of the assets of the debtor will then be paid to the common creditors or the not preferred pro rata regardless of dates of their claims. Section 134 or order removing the debtor from the list of registered entities at the Securities and Exchange Commission. Upon determining that the liquidation has been completed according to this Act and applicable law, the court shall issue an order approving the report and ordering the SEC to remove the debtor from the Registry of Legal Entities. Section 135, Termination of Proceedings. Upon receipt of evidence showing that the debtor has been removed from the Registry of Legal Entities, at the SEC, the court shall issue an order terminating the proceedings. Liquidation of a securities market participant. Section 136 provides that liquidation of a securities market participant. The foregoing provision of this chapter shall be without prejudice to the power of a regulatory agency or self-regulatory organization to liquidate trade-related claims of clients or customers of a security market participant which for purposes of investor protection are hereby deemed to have absolute priority over all other claims of whatever nature or kind insofar as trade-related assets are concerned. For purposes of this section, trade-related assets include cash, securities, trading right, and other assets owned and used by the securities market participant in the ordinary course of its business. Again, Section 136 expressly provides trade-related claims of clients or customers of a securities market participant have absolute priority over other claims of whatever nature or kind insofar as trade-related assets are concerned. Trade-related assets include cash, securities, trading right, and other assets owned and used by the securities market participant in the ordinary course of this business. Chapter 8. Proceedings ancillary to other insolvency or rehabilitation proceedings. Letter A. Banks and other financial institutions under rehabilitation, receivership pursuant to a state-funded or state-mandated insurance system. Section 137. Provision of assistance. So, the court shall issue orders, adjudicate claims, and provide for other relief necessary to assist In the liquidation of a financial institution under rehabilitation receivership established by a state-funded or state-mandated insurance system. Section 138, or the application of relevant legislation. The liquidation of banks, financial institutions, insurance companies, and pre-need companies shall be determined by relevant legislation. The provision in this act shall apply in a suppletory manner. Cross-border insolvency proceedings. So, Section 139, or the adoption of ancestral model law on cross-border insolvency. Subject to the provision of Section 136 hereof and the rules of procedure that may be adopted by the Supreme Court, the model law on cross-border insolvency of the United Nations Center for International Trade and Development is hereby adopted as part of this Act. Section 140, or the initiations of proceedings. The court shall set a hearing in connection with an insolvency or rehabilitation proceeding taking place in a foreign jurisdiction. Upon the submission of a petition by the representative of the foreign entity that is the subject of the foreign proceeding. Section 141, or the provisions of relief. The court may issue orders, letter A, suspending any action to enforce claims against the entity or otherwise seize or foreclose on property of the foreign entity located in the Philippines. Letter B, requiring the surrender of property of the foreign entity to the foreign representative, or letter C, provide other necessary relief. Section 142, or factors in granting relief. In determining whether to grant relief under the subchapter, the court shall consider, letter A, the protection of creditors in the Philippines and the inconvenience in pursuing their claims in foreign proceedings. Letter B, the just treatment of all creditors through resort to a unified insolvency or rehabilitation proceeding. And letter C, other jurisdictions have given recognition to the foreign proceeding. Letter D, the extent that the foreign proceeding recognizes the right of creditors and other interested parties in a manner substantially in accordance with the manner prescribed in this act. And letter E, the extent that the foreign proceeding has recognized and shown deference to the proceedings under this act and previous legislation. Chapter 9, Funds for Rehabilitation of Government-Owned and Controlled Corporations. So, Section 143, Funds for Rehabilitation of Government-Owned and Controlled Corporation. Public funds for the rehabilitation of government-owned and controlled corporations shall be released only pursuant to an appropriation by the Congress and shall be supported by funds actually available as certified by the National Treasurer. The Department of Finance, in collaboration with the Department of Budget and Management, shall promulgate the rules for the use and release of said funds. Chapter 10, or the miscellaneous provisions. So, Section 144, the applicability of provisions. The provisions in Chapter 2, insofar as they are applicable, shall likewise apply to proceedings in Chapters 3 and 4. Section 145 refers to the penalties. So, an owner, partner, director, officer, or other employee of the debtor who commits any of the following acts shall upon conviction thereof be punished by a fine of not more than 1 million pesos and imprisonment for not less than 3 months nor more than 5 years for each offense. So what are the offense? Letter A, if he shall, having notice of the commencement of the proceedings or having reason to believe that proceedings are about to be committed, or in contemplation of the proceedings, hide or conceal or destroy or cause to be destroyed or hidden any property belonging to the debtor, or if he shall hide, destroy, after mutilate or falsify or cause to be hidden, destroyed, altered, mutilated, or falsified any book, deed, document, or writing relating thereto, if he shall, with the intent to defraud the creditors of the debtor, make any payment, sale, assignment, transfer, or conveyance of any property belonging to the debtor. Or letter B, if he shall, having knowledge, belief of any person having proved a false or fictitious claim against the debtor, fail to disclose the same to the rehabilitation receiver of the liquidator within 1 month after coming to said knowledge or belief, or if he shall attempt to account for any of the debtor's property by fictitious losses or expense, or letter C, if he shall knowingly violate a provision or knowingly fail to undertake an obligation established by this act. Section 147, or the application to pending contract. This act shall apply to all contracts of the debtor regardless of the date of perfection. Section 148, repealing clause. The Insolvency Law Act number 1956 as amended is hereby repealed. All other laws, orders, rules, and regulations or parts thereof inconsistent with any provision of this act are hereby repealed or modified accordingly. Section 149, the separability clause. If any provision of this act shall be held invalid, the remainder of this act, not otherwise affected, shall remain in full force and effect. And lastly, Section 150, the effectivity clause. This act shall take effect 15 days after its complete publication in the official Gazette or in at least 2 national newspapers of general circulation. Here is a sample bar Q&A. Hortensio owned a modest grocery business in Laguna. Because of economic downturn, he incurred huge financial liabilities. He remained afloat only because of properties inherited from his parents who had came from landed families in Laguna. His main creditor was Pure Silver Company, the principal supplier of the merchandise sold in his store. To secure his credit with Pure Silver, he executed a real estate mortgage with a dragnet clause involving his family's assets worth several millions of pesos. Nonetheless, Hortensio, while generally in the black, now faces a situation where he is unable to pay his liabilities as they fall due in the ordinary course of business. What will you advise him to do to resolve his dire financial condition? Explain your answer. The answer: he can file a petition for rehabilitation. Corporate rehabilitation contemplates a continuance of business life and activities in an effort to restore and reinstate the corporation to its former position of successful operation and solvency. The purpose being to enable the debtor to gain a new lease of life and allow its creditors to be paid their claims out of its earnings. Though Hortensio is a natural person and not a corporation, rehabilitation is possible considering that Freya covers an insolvent debtor, whether a natural or juridical one.